While he was driving the vehicle, there was minor children in the car, one of which was an 8-year-old child who told the police that while she was in the car, she heard the defendant saying that he was going to crash the car. She experienced that he was driving really fast, and then when they got home, she watched as he was choking her mom.
This hearing moves fast, but the stakes are explosive. Prosecutors say the defendant didn't just violate bond. He allegedly flooded the victim with calls from jail. 86 attempts, 23 completed. And it doesn't stop there. They claim he even helped another inmate break their own no-contact order. Now the court is staring at a dangerous pattern: alleged violence, alleged intimidation, and alleged defiance of court rules. The defense says, hold on, these are still just allegations. But watch the judge closely. Because if the court believes this shows disregard for authority, bond isn't just at risk, freedom is.
People versus Christopher Farner. What are we doing?
Your Honor, at this time we wish to set the for exam.
Preliminary examination in person will be set June 4th, 2024, 9 a.m. before Judge Washington.
I have kind of two options to my request, please. One is I'm requesting that his original bond be ordered at $200,000 half. That is the request that we made at the time we charged it, and my position is that's what his bond should have been set at based on the facts of this case. In the alternative, I'm asking that Your Honor revoke the defendant's bond and remand him today for his bond violations. So I'll start with the bond violations, perhaps. After the defendant was arrested and in custody, and after he was arrested, he made 86 attempted calls to the victim, and 23 of those calls were completed. I had the opportunity to download a PDF and send that to defense counsel, as well as download the 23 completed calls. I did also accidentally download some of the incompleted calls and sent those her way as well. But she's had access to them since yesterday, which is when I discovered them. I have not had the opportunity to listen to the content of all of the 23 completed calls. Of the calls that I was able to listen to, I was able to listen to the defendant talking to the victim about arranging his bond posted, arranging his pickup at a gas station near the jail, the two of them talking about how to get the no contact order dropped, about how they can have contact with each other once. So I'm requesting that his bond be revoked and that he not be permitted phone privileges in the jail for those violations. In regard to, and I should also note in terms of the jail phone calls, this is the defendant from Mr. Gates' case earlier when I mentioned that he had another defendant from the jail call and asked his victim for another phone call.
The other number?
Yes, this is Mr. Fleischer is the person that participated in that, and he's the one that called her victim. Or excuse me, Mr. Gates' victim. So in regard,
so he called the victim in the other case to get a new phone number so that that defendant could contact that victim.
Correct. Thank you, Your Honor. In regard to the facts of this case, the defendant, and I'll kind of jump to the end and then go back through it. The defendant at the end of this admits to the police that he was intoxicated while driving the vehicle.
Now the narrative turns darker. Intoxicated driving, kids in the car, and threats to crash. Prosecutors are stacking danger on top of danger. In bond hearings, this kind of alleged behavior screams one thing to the court: unpredictability behind the wheel and at home.
While he was driving the vehicle, there was minor children in the car, one of which was an 8-year-old child who told the police that while she was in the car, she heard the defendant saying that he was going to crash the car. She experienced that he was driving really fast, and then when they got home, she watched as he was choking her mom. The victim is that child's mom, who reported to the police that in the car, the defendant decided to begin an argument with her, calling her a psychopath, saying to him that she could not take his guns away from him, that he hit her in the head while he was driving, and actually while he was still driving the vehicle, began to strangle her. The victim reported separately from the interview with the child, reported that the defendant told her while he was driving the car that he was going to crash the car, kill them all, and that it would be her fault. He said that with children in the car, and that the 8-year-old subsequently cooperating that. As I mentioned earlier, he had consumed alcohol, and he later admitted to the police that he was intoxicated at the time of driving that vehicle. In the vehicle, put both of his hands around the victim's neck and strangled her. She couldn't breathe. At a stop sign, the victim tried to get out of the car to flee, but the defendant sped off. Once they were home, inside the home, both of her parents were present, and her parents were interviewed separately. The victim told the police that the defendant choked her and threw her to the ground. The victim's father, who was present, said that he walked in and he saw the defendant with the victim in a chokehold, that he said, "What the F," except he actually swore, "Are you doing?" And the defendant immediately released her, throwing her to the ground. The mom also was interviewed separately. She said that she saw the victim push the defendant, and that the defendant then put his hand on the victim's throat and began pushing her by her neck, and that the mom then left the room and did not see what else happened. The police observed redness on the victim's neck, a V shape. They put in the report as a blood blister near her trachea. And those are the injuries they observed of her. So just based on the facts alone of this case, I am reviewing my office's response to that would have been the appropriate bond to set at the time. However, if your honor is inclined to, frankly, I'm asking that you just revoke bond completely, set him a bond, remand him for these jail calls and contact he's had.
Before we even get started here, pay attention to the tone in this courtroom. Judge Fleischer is clearly frustrated, and that usually means one thing. This defendant has already pushed the court's patience to its absolute limit. Missing court dates is one of the fastest ways to get on a judge's bad side. Let's see exactly why this situation escalated.
And order that he not be permitted to use the phones in the jail. Thank you, Your Honor.
Response.
Thank you, Your Honor. Our ultimate request is to keep bond set as where it is. As to the allegations of this case, I will just point out they still are allegations. And upon review of discovery,
the defense leans on a classic move. These are only allegations. Legally fair, but notice what's missing. No hard pushback on the call logs. When the paper trail starts talking, judges tend to listen very carefully.
My client does maintain that a lot of what is in the report is incorrect. As to the jail calls, that is correct. Ms. Hughes did.
A lot or all?
Well, some of the identifying information would be correct in the report, but the allegations that would be criminal, my client denies. As to the jail phone calls, that is correct. Ms. Hughes did provide me with both the log and a folder with the calls in them yesterday afternoon. I have had the opportunity to review the log. However, I have not reviewed the substance of the calls in their entirety. I would acknowledge that some of the calls were made to the complaint witness's number and arraignment. However, to my understanding, there are no allegations of any other bond violations, either contact or otherwise, since my client's released from the Washtenaw County Jail.
What about his participation to facilitate another individual violating their bond condition?
The first I'm hearing of that is today, Your Honor. So I can't speak as to that whatsoever. I am asking the court to keep the bond set as where it is. Mr. Feiner has been out for, I believe, how long have you been out since posting the bond?
Last week, Thursday.
Last week, Thursday. So exactly 1 week, Your Honor, to my understanding. In that week, he has not had contact with the complaining witness nor violated his bond in any other way. We are asking for it to stay as is so he continues showing up to court. And he has been very active in the defense for this case. He is a foreman for a construction company and does have full-time work providing for his 5 young children. We are asking the court to keep bond where it is at this time.
Well, I don't know why the bond was set on those facts. Is he on a tether?
Yes, Your Honor.
Given the facts of this case, or at least as they're related to the court, I believe that the bond as set is an abuse of discretion. Everything that's mentioned is high lethality. The alleged victim in this case ended up at least going to the hospital to tend to wounds that she is alleging were caused by the defendant. Moreover, then that after all of this occurs, and what causes the court a great concern is to the defendant's conduct is that there are these contacts that aren't supposed to be contacts while he's in the jail that then also then while he's in the jail, and I don't have any reason to dispute it because I had to revoke that other individual's phone privileges. He facilitates, not only does he violate a condition of his bond, he then facilitates another inmate violate the bond in the case or in the other case. Not going to happen. It's just simple. I think the bond initially was set wrong. His behavior since then would lead this court to believe that the defendant cannot conduct himself reasonably, would also then pose a danger not only to the community, but to this particular victim and to the community as a whole. Defendant's bond, and he hasn't complied with the bond as we've said it, Mr. Allen. Defendant's bond is hereby ordered revoked. His phone privileges are also ordered revoked. Defendant is remanded.
Bond revoked. Phone privileges gone. The judge made it clear court orders aren't suggestions, and repeated violations erase trust fast. In the end, the court weighed the defendant's choices against community safety, and safety won. Do you think the judge was right, or did the defendant waste his final chance? Comment below, hit like, and subscribe for more real courtroom breakdowns.
Court is calling 2021 CR 9283, State versus Jeremiah Johnson. Can I have parties approach and announce for the record? Good morning. Announcements.
Brandon Brady for the state.
Stephen Harkowitz for Jeremiah Johnson.
And are you Mr. Johnson?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jeremiah James Johnson who was placed on community supervision in 2021 CR 9283 for the offense of possession of a controlled substance, penalty group 1 to 4 grams on June 1st, 2022 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Judge, we're seeing on a violation of condition number 2, specifically that on or about the 20th day of June 2024 in Uvalde, County, Texas, the defendant, Jeremiah James Johnson, is then and there illegally used a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
Not true. That's true.
All right, so to that violation of number 2, you plead not true? All right.
I'm sorry, Judge, is that true or not true?
He said he's pleading true.
Thank you.
State?
Judge will also be proceeding on a violation of condition number 4, specifically that in Berry County, Texas, the defendant, Jeremiah James Johnson, is then and there failed to report to the supervision officer as directed for the month of July, August, September, and October of 2024, violation of condition number 4.
How do you plead to that? True or not true?
The state will waive the remaining allegations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 2 and 4, the court could find it true, grant the motion, and sentence you up to 3 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 2 and 4?
Yes, ma'am.
Court will find 2 and 4 true. Is there a proposed agreement?
Judge, the agreement is to revoke the defendant. It's looking like he got out of TBC around.
Well, I mean, you guys are agreement to revoke. And what are y'all asking for?
Judge, we're asking for the full 3 years.
And is that the agreement?
Judge, and well, Mr. Johnson is asking for some credit.
No. So first, I like to go through steps. So the first thing, are you all in agreement that he is revoked?
Yes,
Are y'all in agreement that he be sentenced to the 3 years?
yes.
All right, so the court is going to revoke. The court, and are you waiving your right to appeal?
Yes, ma'am.
All right, so the court is going to revoke. The court is going to sentence him to 3 years in the prison. give you credit for any time served. So it appears that what you all were trying to tell the court is how much time you have. The
Yes.
person who needs to know the exact time you have or you're saying you have, the clerks, because the clerk needs to put it in the system. What I can tell you is I'll give you credit for any time that you've served on this case. So anytime a warrant has been active on this case, you get credit for that. Anytime you've been waiting in jail to have this heard, you'll get credit for that.
Okay, so.
If you had some other case that you went to TDC on and this was still pending, you'll receive credit for that.
Okay.
Okay?
Yeah, yes, and that's where we're getting at. It's my
Okay.
understanding from checking with the clerk last week, he's got 135 days in Bear County.
Okay.
Now, he had cases in Uvalde? Medina County, excuse me. And that he went to a rehab from 1/27/23 to 7/20/23. That was 175 days. And what Mr. Johnson is telling me that when he went to the rehab for the cases in Medina County, he was supposed to be given credit for was it an outpatient or
Yes.
here on the cases
Oh,
that he
well, I
had
can
here?
tell you is I cannot legally give you credit for any outpatient treatment. Now, if you successfully completed inpatient, then you can receive credit for that. But for outpatient treatment,
No,
the court legally cannot give you credit for that.
it was a 6 months inpatient program at CCF in Uvalde County.
Okay.
And you guys used it for my outpatient program I was supposed to do here, so you guys used my inpatient program. So that's why I was trying to get that credit time
Okay.
for that too.
All right. Anything else?
Yeah, and then in addition, he went to TDC for on 11/15/2024. And he made parole on 1/20, 1/23/26. And they had to detain her
The whole time.
the whole time at TDC, so he's asking the court to give him credit for that.
All right. He'll receive credit for the 135 days in the Bear County Jail. He'll receive credit from January 27, 2023 to July 20, 2023 for successful inpatient treatment. He'll receive credit from 11/15/24 to 1/23/26. Is there anything else?
Yeah, oh, and then he's also asking, Your Honor, to run this case concurrent with the two cases he's on parole. I have the case numbers for
Yes.
that. That's 22-03-14359 CR. Then he has a second case, 20-02-13565 CR.
Wait a minute. -135.
13565 CR.
All right. This run concur with 22-03-14359 CR and 20-02-13565. I'm sorry, 13565 CR.
Correct.
And there's to be no residing with minors. And no unsupervised contact with minors. All right. Did
Okay,
you,
that's
and
everything, right?
I'll ask for the therapeutic community. It doesn't increase the time that you're in custody, but it can help you maintain your sobriety. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yeah.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
All right, make better choices, all right?